Hello and welcome. Today we're going to talk about trademarks and when is it too late? So it's Monday. It's also after daylight savings time. So I think we're all just kind of like blah. Before we get started though, don't forget. All right. I have to put that up just so that we're clear. If you need legal advice, please seek someone local to your area. I'm happy to discuss general legal principles, but if you need specific questions answered, then you do need to discuss that with the local attorney. In case you're new here, which I'm guessing quite a few of you are because I'm getting found new, my name is Taylor Darcy with Think Legal, and I help entrepreneurs and startups intentionally create the business of their dreams. So welcome. I'm very excited to have you here. It's Monday, and it's election week, and we're going to be going live every day this week, just like we did last week, to answer your questions and to help you with your business. So I hope you had a great weekend, and I hope you did well. So let's get started. A trademark is a design, a logo, a phrase, a distinctive mark, a name or work, something that is very specific to you. It can't be too broad. It has to be something that is specific and unique. Otherwise, you can't trademark it. In order to trademark something, and you can trademark things under a mark classification trademark or on a service classification. There are different classifications within a subset of the different marks. So if you are looking at getting a trademark done, you're going to want to pay attention to, like, for instance, different services have different service marks, and that's where the similarities can get you in trouble. So you have to be careful of that. So when is it too late? Well, there are only some times that it's too late. It's very common that if you're doing your due diligence and you get your trademark and you do it in the beginning of your company or the beginning of your business, then it won't be too late. It's that when you start using it or you don't do enough research, you don't look at the USPTO office, and then you can submit it. Now, that being said, if someone has already been applied for and granted the trademark for something, then you're out of luck temporarily. There's a couple of instances, and we'll talk about those in just a second, about when, even if someone else has registered it, that you could get away with, you could get your own trademark done. And then it has to be in the same classification. So, for instance, it can't just be, they can't be too broad when it comes to classifications. So if it's like a sneaker, Nike can only claim classification or ownership over the mark for apparel and thing. They couldn't claim the mark for guitars, musical instruments. Someone else with a musical instrument named Nike might, very unlikely though, get approved for a trademark because of how big the brand of Nike is. Because there's a likeliness of confusion with that. So you'd want to have you'd want to have a distinct name. And that brings to the point of, if your mark is substantially similar to another mark, then you can be denied that way as well. So it can just be that it's too close, or it contains the name of someone else that has already registered that trademark and will cause you to get the USPTO will reject it unless you can prove, and then this is where it gets expensive, unless you can prove that it is distinct or that it's not similar enough. If a trademark is already registered, you could technically contact the owner of the trademark and then license the use of the name from them. More likely than not, you'd have to pay royalties, but it is possible. And so you can do it. It isn't just because someone else already has something doesn't mean that you absolutely are out of it. And then that brings me to the next point. A trademark must be renewed every 10 years. And so a lot of times people won't renew their trademark. And so then that opens it up to other people to claim that trademark. So a lot of times, even if it's something that is traded or trademarked or service marked, whatever it may be, then you can still get away with it later. It just means that you have to wait for them to not renew. And so you won't have access to it for that period of time. The best scenario is that you want to have the name trademarked because it needs to be used in commerce. And you want to have it done, at the very beginning so that you don't run the risk of someone else applying. There are patent trolls and copyright trolls and trademark trolls. They're cracking down on those. They're still, people still have them. It's not the best where people do those. So it's always better to get it done ahead of time and make sure that your brand is protected before you need it. Because once it is, if someone else is using it, then it can be very expensive to fight them and it to cost them money. So if you haven't subscribed, please subscribe and don't forget to hit the bell button because YouTube just requires that for some funny reason. So that you'll get notified when I go live, as well as when I post new videos. If you have any questions, leave them in the comments. I'm here to help you, and I look forward to talking with you and getting to know you over time. So have a great day.